Thank you. Good morning to you all. This is a real challenge to speak before lunch, but we will try, me and my colleagues from the panel that I salute warmly. This is an honor to be here in this conference for many reasons. Of course, perhaps the most important reason is the person of Asma Jahangir. I heard about her for many years. It's a reference not only for Pakistan, but all over the world. The struggles and the courage, the commitment to rule of law and to human rights from her is an example and a model for all of us. This is perhaps the most important thing that I will share with you, is my homage, my tribute to this wonderful person. So I will address you mostly as sharing my experience. Aristotle said that to communicate, to have a rhetorical argument, there are only three ways to communicate with people. The logos, that is through rational thinking. The pathos, that is the emotions that we share with the others. And the ethos, that is the origin of the word ethics. And the ethos is about the narrator, the credibility of the narrator, the experience of the person that is talking to you. I've been a judge for 36 years now. I work extensively on international expertise in 53 countries now. And that doesn't provide me any special knowledge, but for sure, it'll provide me experience. And the experience that I want to share with you, having witnessed in recent years the debacle of rule of law, the uprising of populist regimes, autocracies, and all the problems related with democracy fatigue, as some say. So 2 or 3 brief messages. The first is about international law, fundamental rights under international human rights law. When we speak about international law, and we have here several special rapporteurs, they will know, the first word is crisis. International law is in crisis. We live a very challenging time. The enforcement of international law is at risk. Everyone is talking about the future of international law, but let me bring you a positive approach. This is the name of the game. Crisis is the middle name of international law, and we must have this notion, historical notion, that it goes with the game. Progress in human rights is always a long struggle, and success is always mixed with setbacks. Despite this, we have a very positive legacy. If you look at what are the values, what are the main values for jurists, for law professors, for lawyers, for judges, during the history of our civilization, we can see that everything started with this idea of God. The law was at the service of a divinity of God. And you can see Inquisition, the Middle Ages, still in some countries is operating. Then we have the glorification and the empowerment of the prince. Machiavelli is a name that resonates to this idea of the law at the service of the prince. Then we have the French Revolution in our European culture, and then the idea of the people, liberté, égalité, fraternité, the idea of serving the people was the main issue for the law. And today, in present times, what is the alpha and omega of jurists, of lawyers, of judges, of law professors? Fundamental rights, human rights. So we can see in a global world that international law, fundamental rights international law, is something that marks our main aspiration, our mission as jurists. And that is settled. That is settled since the 20th century, and we will continue in the future. The main challenge, and I will share with you a story that happens to me years ago in Bahrain. The main challenge is, what is the purpose of human rights law? I was in this conference, and this English professor bring two objects with him. One was a wooden duck. This wooden duck, a bibelot that we use in our houses. And the other one was a screwdriver. And talking to an audience like this one, he said that the main challenges for human rights defenders, for jurists that knows that our main principle is to defend human rights, is to avoid this idea of human rights as a wooden duck, as a bibelot. Nice words, nice proclamations, wonderful statements, and nothing happens the day after. No, we need to have human rights as a screwdriver, something that we will use in our daily routines as law professors, as human rights defenders, especially as judges. And when you are talking about screwdrivers as the main instrument for the defense of rule of law and human rights, we must think about the courts. The courts are perhaps the most interesting screwdriver that we had to uphold rule of law and human rights. So the courts are the bridge between international human rights standards and real protection for real people in their daily concrete lives. Some years ago in Poland, that faced a very difficult times, 2016, the crisis of the rule of law in Poland was very important for the European Union. I was there for 8 times in a single year, trying to defend our colleagues, my colleagues, judges that were struggling with new laws, trying to break judicial independence. There was this international expert, a woman, that came to me and said, José, I work in international organization for 10 years on human rights department. But now I make a shift, I change my career. And I decided to work in the rule of law department and to focus on the issues of judicial independence in the courts, to protect and defend the independence of judges. And you know why, José? Because if we have independent courts, it's the best way to protect human rights. It's the best way to protect fundamental rights. So we need to have a structure, and this applies to Poland, to Pakistan, to my country, to Europe, to Asia, whatever. We need to have a strong, solid structure that supports judicial impartiality and judicial independence. And the threats to the judicial independence are so many, but are always the same, regardless of the country, regardless of the region, regardless of the continent we are speaking of. Manipulated appointments, political driven discipline and strategic transfers shrink the rights and the space for adjudication. Appointment and disciplinary so-called reforms can quietly turn courts from human rights guardians into instruments of political convenience of those in charge at the moment. These are not technical details. They cut to the heart of courts' ability to protect human rights in a concrete and effective way, to be the screwdrivers that I talked before. So we need security of tenure, we need transparent and merit-based appointments, we need procedural guarantees that shield judges from retaliation, we need to have freedom of expression for judges when rule of law is at stake, when structural reforms are conditionating the work of the judges. At this regard, judges must be allowed to speak. I'm the president of the Consultative Council of European Judges, and we issued an opinion about freedom of expression of judges. And we issued in that opinion that judges have not only the right to speak, but the duty to speak. Each time judicial independence, rule of law is at stake. This was a quite pioneering approach to the freedom of expression within the judiciary, particularly within judges, but we felt that was the right time to issue that opinion around 3 years ago. So, going to an end, I will leave you with the last message. We judges are not experts with robes. We judges defend the equal right for any citizen. It's a very difficult job. We are always struggling with politics to try to, in a way, to repress our power and to make it a way for jeopardizing the checks and balances that are essential for any system. The best examples where judicial independence, when attacked, prevails, the best examples that we have in different regions and countries where the rule of law at the end prevails, were the countries where civil society was alert, were the countries where civil society was always there to defend not the judges, because judicial independence is not about judges, it's about common citizens, to treat everyone, especially minorities, especially those who are not in power, especially those who are facing opposition, that are opponents, especially these people need to have independent and impartial judges. So a conference like this one should be multiplied all over the country, all over the region, all over the world. A conference like this one, when one can openly speak and discuss what is needed to enhance the rule of law and to enhance judicial independence, is something mandatory for those who work on this field. I was speaking about Aristotle, about the ethos, the pathos, and the logos, and I will end again with Aristotle, because the Greeks, many centuries ago, they taught us everything. We just must repeat. Aristotle said, "For men, when men are perfect, they are the best of all the animals on earth. But when they are separated from law, from justice, from these rules that I've been speaking about it, they can be the worst animals on earth." Thank you.